Yes.
Yeah, right.
This is case number 20-152689. This is Fine and Held P LLC versus City of Detroit. Matter is before the court. I have it set on for review on today's date. For the plaintiff in this matter, your appearance at this time, please. Mr. Coleman, looks like you're still on mute, sir. The darndest thing now. *6 may get you off of there.
There we go. Okay. My cursor disappeared. Yes, Howard Cohen appearing on behalf of the plaintiff, P41346, Your Honor.
All right, thank you, counsel, and good morning to you. For the City of Detroit, your appearance at this time, sir.
Good morning, Your Honor. Philip Hiltner, P779134, for defendant.
All right, thank you, Mr. Hilder. Good morning, of course, to you as well, sir. So somebody update me here. I see that I set it on for review, and we were just here on, well, I think the last time you were here was in September. All right. Update me, Mr. Cohen.
Unfortunately, I wasn't here in September, so I just was assigned the file, so I don't know what happened the last time we were here. Maybe Mr. Hiltner does.
Yeah. Not much, frankly, has happened in the last 6 weeks, Your Honor. Mr. Cohen did just reach out to me. I mean, discovery's been closed for some time. I don't see a need to continue discovery unless there's something specific they need. There haven't been, frankly, serious settlement negotiations, but this case is tricky. I mean, we have video of the accident. This is a PIP provider case. There's bus surveillance video of the accident, and frankly, it's not good for plaintiff. If plaintiff doesn't have a copy of that, I'll gladly provide them a copy if that'll help. But beyond that, I'm not sure what else there is to do.
All right, so I know that there was a summons for intervention. So
New Horizon was the chiropractic treater, and I think we're probably going to dismiss them from the case. They have a bill that they found for $670, but they can't find the matching medical records to go with it. So with no medical records, no case.
Well, that's usually the way it works, I'm saying.
Right.
Some magicians before, but that's usually the way it works there. Yeah. All right. So that may resolve at least that part of it.
Right.
But I'm a little bit either shocked or intrigued, or a combination of both, that there hasn't been some settlement discussions along the way where you've had an extensive period of adjournment. But given that that counsel for the city has a video that's worth 1,000 words, that could explain why there hasn't been much activity in this regard. Do you have a copy of that video, Mr. Cohen?
I don't believe I do. I would like a copy, obviously.
Thank you, Mr. Hilner, for bringing that up so that we could get that taken care of.
And I don't know if this is something we can settle on our own, or case evaluation will help.
I set up a breakout room just for the two of you so that you could commune or commiserate regarding the implications here, and see if there's something that you might be able to talk about. So why don't you take a moment there and come back?
Sure.
I'm certainly trying to give some time if you need it, but I want it to be meaningful as we go forward. So I'm going to give you I'm going to connect you to breakout room number 1. You receive a notification. Come back. All right, John. And Madam Counsel, which matter are you on, South?
Crystal Love versus Sweet Living Towers. I'm the attorney for the defendant.
Gotcha. Okay. All right, this is case number 21-240094. This is Crystal Love versus Sweet Living Towers LLC. The matter is before the court on the filing of a motion for summary disposition. The matter is set on for hearing on today's date. Your appearance at this time, counsel.
Good morning, Your Honor. Attorney Elizabeth Ellison, P8209, on behalf of the defendants, Sweet Living Towers.
All right, thank you, Madam Counsel. I'm looking for Crystal Love or anyone representing Ms. Love. And I note that this matter is set on for 9:45 a.m. The court also notes that that in regard to the notice that was sent out, that it does have the correct Zoom address, indicating that it is a virtual hearing set for this date and time. And I make that record because on previous occasions I had a different Zoom address, but this notice went out October the 11th, and it has the correct Zoom, all of the appropriate information. Let me ask you, Madam Counsel, have you had any occasion to speak with Ms. Love recently? Any communication since the last hearing date?
Yes, Your Honor. She did call me immediately after the last hearing date and asked if there was any chance of my client offering her any money. I advised her no. But as of the last hearing date, you did advise her that the motion was pending and that she needed to submit an answer to that motion, and we still have not received a response, Your Honor.
Yeah, I'm looking through the file to see if there was any written response. I did not see one initially, and I directed the same at the last hearing. And the defendant has not in any way responded, nor has she appeared in this hearing today. Given that it's now 10 o'clock a.m. And the defendant has not filed a written response to the motion for summary disposition, the court will grant the motion at this time, and judgment will enter for the an order will enter for the defendant in this matter, resulting in this case, in fact, being dismissed under the motion for summary disposition C8 and C9 provisions. All right, counsel, you can submit an order and I'll sign it and get it back to you. You have the email address to do so, ma'am?
I do not. Can you give that to me one more time, Your Honor?
Yes, ma'am. That's Latifah, LATIFAH.Hunter at 36 District Court.org.
And I will get that right over to you, Your Honor. Thank you so much.
Good day to you.
You as well.
Was she the plaintiff or the defendant?
Defendant.
Was she the defendant? Oh, they have her on here as the plaintiff.
I'm sorry.
They have her down as the plaintiff.
Love is the plaintiff.
Yeah, okay.
She was representing,
Oh, okay.
counsel was representing Sweet Living Towers.
She got a judge.
So the defendant's motion is correct.
Okay.
All right, we're back on the record regarding Spine and Health PLLC versus City of Detroit. The suffix on that is 2689. All right, gentlemen, you got it all worked out, and you agreed to send in the order.
Not quite.
All right. So,
I guess Mr. Hiltner is going to send me that videotape so that I can review it and make a recommendation to my client. He's indicated to me roughly what's gone on with other claims in this case. And I was wondering if perhaps we might have put this over 30 days to see if we can settle it.
all right, that makes sense to you, Mr. Hillman?
That's right. That's I think that's a good plan.
All All right, real good. Glad you had the opportunity to talk about it and maybe find some direction here. So I'll go ahead and extend an additional 30 days to try and get this resolved. That's probably going to put you a little bit out for 30 days because I'll be away for a short period there. So the next action date is going to be December.
You have December the 21st.
Oh, I need something early.
You were off that first week. You want the
As soon as
those
I'm
weeks. As soon as you're back, you have the you can try the 15th.
December 15th,
Okay.
12, 15, 21. And I'll set that on at 9:30 a.m. and I'll leave it as a review hearing. Yeah. You know, if that has to change or setting it for trial or anything, we'll deal with that at that time. All right. So hopefully you get it resolved. If not, we'll be talking, figuring out at that time exactly which direction this case is. All right,
Okay.
gentlemen. And
Okay.
thank you.
Thank you.
Thank you.
Thank you, Your Honor.
All right. That's just a review, so that's why. It won't be any-
Okay, we've had, I just put it on that day. I think you only got like 4 of the cases on that day.
This is case number 2164661. This is Affiliated Diagnostics of Oakland versus City of Detroit. This matter set on at 10 o'clock a.m. For a motion or a settlement conference. There have been some discussions between the parties on a previous occasion. Your appearance for the city, as I do not see counsel for affiliated. Counsel, you may at this time, sir.
Good morning, Your Honor. Alfred Asher on behalf of defendant, City of Detroit, P82536.
All right, Mr. Chu, good morning to you and welcome to the month of November. All right, looks like someone may be coming in on Mr. Lowen. All right, for the plaintiff and Affiliated Diagnostics, please.
Good morning, Your Honor. James on behalf of the plaintiff.
All right, and your P number, just for the record.
It's P63110, Your Honor.
Thank you, counsel. Good morning to both of you. I know that I adjourned this and set it for a settlement conference today. Somebody update me. Where are we at this point?
I show from my notes that we had sent over a settlement demand. I didn't see where we had heard back. This was back on 8/25. We generally work these out. Our two firms have a lot of these cases in common.
Mr. Ashu, did you get the?
Yes, I do see that demand. However, it's not one that we could accept. But if you would grant us, me and Mr. Lowe, a chance to discuss off the record, possibly we might be able to get it resolved.
I'm sending you now to break out rule number 1. It's the golden rule.
Certainly. Thank you.
All right, there you go. back, gentlemen.
Thank you, Judge.
Your Honor.
Where are we?
Your Honor, we did have discussions, but we weren't able to reach an agreement. There is a bit of a gap between the two parties, but we're at the end of the underlying payments case in circuit court, and the outcome of that might allow us to resolve this case. Right now, we just asked the court to continue the track of the case, and we'll work individually to try to resolve it.
I agree, Your Honor. Normally I would suggest that we were sent a case evaluation, but my understanding is that the 36th District Court doesn't really have a mechanism for case eval. When I spoke with counsel about the underlying case, we would also suggest to intervene, but given that counsel said that they're nearing the end of that case, we won't be let in. So really, if we can get maybe a trial date, that certainly tends to help us resolve these. And again, like I said, counsel and I, our two offices work well together, and we tend to resolve these. But we've got a gap between us right now.
Right. Now, one of the things that I have been doing is I've been signing an order for mediation over to the tribunal. While we do not have an official relationship connection in that regard, I've been signing orders directing the case to be mediated. You take a copy of that and send it over to the tribunal, and I've not known them to turn down the payment for a mediation session. So that's at all helpful. Go ahead, Councilman.
I think that would be very helpful. I'm pleased to hear that that's been done before, because I think spending the $75 on each side and getting in, the panel of three to take a look at this, I think that would certainly help us.
All right. What do you think, Mr. Ashen?
I'm not in favor of it personally, Your Honor. It doesn't really affect, on these PIP cases, it doesn't really affect how we value the case. It's a little different when it's a, third party case or something like that. Then I think those are a little bit helpful. But on some of these lower dollar amount cases and, a straight PIP, I'm not sure that they would be beneficial to us.
Well, the hard thing here is that it's from the court's perspective, the opportunity for an alternative that may give additional insight into resolving a dispute. It's kind of hard to pass up on that. So I'm gonna order the case to mediation, and I'll sign an order. You can take that and get it set up over there. What used to happen is we used to set it up here. We had a connection. We set up that way. What I do is I sign an order saying the case is sent to mediation, and you take that and enforce that order at the tribunal. And then I'll give you a return date. Hopefully, when is the other case ending up? The third party case in circuit?
It's at the end. Discovery is closed on it. I don't have an exact date right now, but
no trial date or anything.
Not that I know of right away. But I don't know exactly what they're doing in circuit court as far as the trials anyway.
All right, so I'm gonna, I know this has been a case going on since 2020, and so that's one of the challenges here. I'm gonna go ahead and put you in January. And I'm gonna get an order out today, and you'll get that order, and then go and get mediation set up so that you can at least see if that helps at all. And then you'll have a date that's left available to you to come back.
We'll try January 6th.
And I can do that as early as January 6th. Let's put maybe the 10th or so.
You want a little bit later, okay. January the, okay.
10th.
Mhm.
1/10/21 at 9:30.
That's our return date, Your Honor, and we're supposed to mediate between that time?
Yes, sir.
Okay.
Would you like my office to draft that order for your signature?
I probably got one that's halfway drafted.
Okay.
Not that I'm looking for that to do, but I'll get that out to you today.
Okay,
And so I think we should be all set.
sounds good. And
Yes.
you said January 10th. I know you said 21. I'm sure you meant 22.
That's what I meant, was 22. That's right.
Yeah.
Thank you, sir. I appreciate that.
Certainly.
All right. All right, gentlemen, I wish you well. And we're approaching the holidays, so if I don't see you before then, there's great chances that I will see you. The best of the season to you. All right. Good day to you.
To you too, Your Honor. Thank you very
Thank you,
much.
Your Honor.